Once again, we'll look at the considerations and concerns that a plaintiff may have that the other side is altering, holding back certain documents, some information that could be helpful to the plaintiff in pursuing his or her personal injury action. In the last blog, we talked about ethical rules that impose upon the other side's attorney, as well as your own, a duty to be candid to the tribunal, to the court, not just at the trial, but throughout the case, and a duty to be fair to the opposing counsel. And fairness has been construed as requiring that no document that has, quote, evidentiary value be altered or destroyed, and the lawyer has great obligations to ensure that that is not done, and if it is done, the lawyer, A, has to remedy it or even bring it to the attention of the tribunal. So those are very, very strong sanctions and measures. There are additional ones. In this blog, I'll touch on them briefly. And they come from cases in Massachusetts that govern the way we conduct litigation. And the principle behind those cases is that there be fairness in the litigation. And I'm discussing this because I want to relieve any concerns a client may have that the other side won't play fair in the course of the litigation, and that will be or would be to the detriment of the client. That doesn't have to be the case given aggressive lawyering, given that that side is met with aggressive lawyering. The courts are willing to consider, in the appropriate cases, sanctions. And the quote is, sanctions in a civil action are addressed to the precise unfairness that would otherwise result. For example, an expert's testimony may be excluded so that an expert would not have the unfair advantage as posing as the only expert with first-hand knowledge of an item. So evidence can be stricken, can be precluded from being introduced because one side has records or copies of things that they did not share with the other side. Now, there's a whole doctrine, a whole notion of spoliation and what happens when one side does hide, conceal, fail to reveal certain documents. In Massachusetts, the court seems to pride itself on going further than other jurisdictions. And there's a quotation that I will put in the written blog as well. Where evidence has been destroyed or altered by persons who are parties to the litigation or by people who are affiliated with that party and another party's, think our plaintiff's ability to prosecute or defend the claim has been prejudiced as a result because of that other side's destruction or alteration of records, we have held that a judge may exclude evidence to remedy that unfairness. In doing so, the court says we've gone farther than other jurisdictions, many of which address this concept of spoliation merely by permitting an adverse inference against the other side. Here, there is an exclusion of evidence. So when you couple those things from the last blog, the ethical rules on an attorney of honesty, candor, full disclosure, and case law, which actually issues rulings that will stop a party's bad behavior, you can go to bed at night knowing that you should get a fair shake in the litigation, and however mean-spirited the other side may be, they can be called to account. Thank you.